Hello everyone, welcome to the channel of FDVN Law Firm. In today's topic, we will share with you the issues regarding the termination of foreign investing enterprises in Vietnam. First of all, let us show you the conditions and cases of dissolution of foreign investing enterprises in Vietnam. There are 4 cases that a foreign investing enterprise shall be dissolved. Firstly, the operating period specified in the company's charter expires without an extension decision. Secondly, the enterprise is dissolved under a resolution or decision of the owner for sole proprietorship, the board of partners for partnerships, the board of members and the owner for limited liability companies, or the general meeting of shareholders for joint stock companies. Thirdly, the enterprise fails to maintain the adequate number of members prescribed in Law on Enterprises 2020 for a period of 6 consecutive months without carrying out the procedures for converting the type of enterprise. Fourthly, the enterprise registration certificate is revoked unless otherwise prescribed by the Law on Tax Administration. The condition for enterprise to proceed with dissolution is ensure the payment of its debts and liabilities, and is not involved in any dispute at the court or arbitration. Relevant executives and enterprise whose enterprise certificate has been revoked are solely responsible for the enterprise steps. Then, we move to the procedures for dissolution of a foreign investing enterprise when the dissolution is made under its decision. The dissolution of a foreign investing enterprise needs to go through the following basic steps. Step 1. Terminate the investment project. If a foreign investing enterprise is granted an investment registration certificate or equivalent document, apart from carrying out the procedures of dissolution of the enterprise, the investor shall notify and return the investment registration certificate within 15 days from the date of termination, and close with a copy of document recording the termination. The investment registration agencies shall notify the termination to the relevant agencies. Step 2. Submit the dissolution documents to the tax office. Enterprise send an official letter to the tax office and close with a notarized copy of the enterprise registration certificate and the tax registration certificate to request the tax finalization and identification. Depending on the reality of the enterprise accounting records, the procedure to close the tax court will last from 6 months or more, excluding the procedures for handling the violations and late submission. In the process of carrying out tax finalization procedures, enterprises carry out procedures to reduce labor and settle relevant regimes for employees within the time limits specified in the labor code. Step 3. Submit application for dissolving the enterprise. Within 7 days from the date of completing the debt obligation, the legal representative of the company must send the dissolution registration dossier to the Greenville business office, where the company's head office is located, or through the National Business Registration Portal. Then, the most common question is how the debt of foreign investing enterprises will be resolved when the enterprise is dissolved. The debts of enterprise are prioritized for payment as follows. First, the enterprise must pay debts in salary, severance allowance, insurance and other benefits of employees under collective labor agreement and labor contract signed. Second, tax debt should be paid after the first steps, and the last if the other debt, if any. After paying the cost of dissolution of the enterprise and debts, the remainder shall be divided among the members and shareholders of the company in proportion to their ownership of contributed capital and shares.
In case the enterprise has unpaid financial obligations, it must include the resolution or decision and debt settlement claim to its creditors, persons with related rights, interests, and obligations. The debt settlement claim must have the name and address of the creditors, debt amount, term, and place and method of payment of such debt, and method and time limit for settling the creditor complaints.
Regarding the dissolution of business, the liquidation of assets is equally important. The enterprise dissolves directly the liquidation organization of enterprise assets unless the company's charter provides for establishment of the separate liquidation organization. Before carrying out the procedures for handling assets upon dissolution of the enterprise, the company must fulfill the obligation to pay on debts of the enterprise under the provisions of law. After the obligations have been paid, if there are still assets, the enterprise may divide the assets of the members according to the contributions of the members or the agreement of the members. The order of liquidation of enterprise assets is as follows. Step 1. Establish counsel to handle fixed assets upon dissolution of the enterprise. Step 2. Conduct the inspection and assessment of the quality and residual value of fixed assets. Firstly, the inspection and assessment of the property is carried out as follows. The council will be able to rely on specific factors such as the damage encountered during use, the time record of the warranty regime, and the number of times of repair and maintenance of property, the necessity level of use and fuel consumption, etc. Second, after checking the condition of the property, the council chooses a method to handle the property such as auction of assets, sell or announce the public sale. Step 3. Proceed to sell fixed assets. And the last thing that businesses are concerned about is the impact of prolonged losses on the business dissolution procedure. A business with long-term losses is not required to be dissolved, so the dissolution will be related to the ability to cope with the loss. If the state of loss and insolvency lasts for more than 3 months, the enterprise is likely to be required to open bankruptcy proceedings and be declared bankrupt by the court. At that time, it will be resolved according to bankruptcy proceedings according to Vietnamese law. So, that's all the information shared by FDVN on the dissolution of foreign investing enterprises. Hopefully, this video will be useful to you. And don't forget to like and subscribe to our channel to receive more useful information. Goodbye and see you again.